Good morning, everyone. We're going to wait a couple of seconds and let more people in from the waiting room. Okay, it looks like the majority are in. Welcome to the last Q&A for September. We're going to start with our usual Zoom housekeeping tips. You will find your mute and unmute and start and stop video buttons usually at the bottom of your screen. You aren't required to have your video on. If you choose to, that's great. If not, that's fine too. We ask that everyone stay muted during this Q&A so that background noise is minimized. You can unmute yourself to ask a question or ask for clarification. Generally, that's easier in the chat. And the chat is at the bottom of your screen as well. We ask that you use the chat to ask for clarification or ask questions and not to get into conversations or start arguing. I know everyone here has been absolutely fantastic about that. It's not meant for discussion like you see in the Q&A, in the CAI message boards. So speaking of the CAI message boards, this Q&A is for general legal information. It is not legal advice. We cannot give legal advice in this forum. And the only way we could give legal advice is if you were one of our clients and we had your documents in front of you. As you will see throughout the Q&As, both today and in the future and in the past, a lot of the questions that get asked are a little too specific for us to answer in this forum, just because it asks for specific details that we can't give general information on. Unless we have your particular circumstances and your particular documents to answer that question, we generally can't. So just keep that in mind when you're asking questions. If you're accepting provisions from the statutes or your governing documents or referring specifically to specific sections in your governing documents, it may be too specific for us to answer.
I want to add that we frequently have people ask questions and omit important facts because they know that those facts might cause a different answer, and they are so intent on getting a specific answer from us that they do not give us complete information. So,
and honestly, that happens as well when clients send us an email and ask for legal advice. So if you want a specific answer, honestly, let us know what answer you're looking for, and we can tell you if there is a legal basis for that particular answer. Sometimes we can't. It really depends. So again, this forum is not for legal advice. It's for general information that's applicable to most communities, or as many communities as we can make the answer general to. So moving on, the Corporate Transparency Act is still being challenged by National CAI. There's a lawsuit in the works for that. We recommend waiting probably until mid to late October before determining whether or not determining how you're going to comply with this. Please note that the report is due January 1st of 2025. So if you have if you already have the like global entry or TSA pre-check, the information for that is similar to what's required by FinCEN. So you can go onto the FinCEN website and get a FinCEN number. With that FinCEN number, you can just give the number on the report and you're done. You don't have to give the specific information required once you already have the FinCEN number. And we note over the past couple weeks, there's been several law firms and management companies that are offering to report, to draft the report for their clients or other associations, often with significant fees. It's up to you whether or not you want to take advantage of that. But if you have the FinCEN number, the reporting is probably 10 minutes or less. So just keep that in mind. We recommend waiting probably until about mid to late October before determining how you're going to comply with this. But just note that compliance is required and due January 1st.
And
So,
if the legislature passes a bill, which CAI is pushing for, or the courts stop its implementation. Excuse me, go ahead.
no worries. So our last bit of general housekeeping is CA Day is coming up. It's not this weekend, it's next Saturday, October 5th. This is the major trade show for Washington State CAI. There are educational seminars to go to. A lot of vendors have booths. We will have a booth. So if you want to meet us in person or speak to us, we'll definitely be there. Katie and Ken will be doing a presentation on what you must do or what you can't do when Ukiah is your statute. And then Valerie is also co-presenting, I'm sorry, with the CAI lobbyist and the chair of the LAC, that's the Legislative Action Committee, on a 2024 legislative update. So we hope to see you all there. It's a fantastic show. It's good to meet people, and it's a great way to network and get information. So I think that's it, unless you had something else to add, Ken?
No, I'm good, and I'll take the first question. So based on statute 6434-384, if a new act condo association pays its annual taxes from its reserves, would this require a repayment plan and notice to the owners? So the short answer would be yes. If you pay for taxes out of your reserve funds, it is not related to maintenance and repair, and it would require compliance with notice and a repayment plan unless it would present an unreasonable hardship. Taxes should be part of your annual budget and paid out of operating funds, not out of reserves. But towards that, most people don't understand that the income is not part of your reserves until it is transferred into reserves. So if you've got $10,000 of income, even if it is coming from reserve assets, you can pay the $3,000 of taxes and then submit the $7,000 net into your reserves. Right? You are not paying taxes from reserves in that case. You are receiving income the same as you're receiving any other income. You are paying the taxes as an operating expense, and you are then transferring the net into your reserve account. And you might want to also talk with your CPA or whoever is doing your accounting and taxes. Even if the asset that is earning the income is a reserve asset, which it is going to be in most cases, that does not mean the income starts as a reserve asset. It starts as income on the operating side of the balance sheet. So we also would recommend, you're not using the reserve account as a savings account for other purposes. It has a specific intent. We would recommend that you have, in addition, a buffer or working capital account with your operating side so that you can take care of expenses that might come either not in sync with the receipt of your monthly dues, or that are unplanned so that you can pay them out of the operating account. And it is okay to delay making transfers into reserves if you have timing issues to pay for taxes or insurance to make sure that you're kind of balancing your budget on a regular basis. Did you want to add anything, Jennifer?
Well, we have a follow-up question. Is interest income from reserve accounts operating or reserve funds?
Well, my opinion, and of course, I'm not the CPA. My opinion is that all income starts on the operating side of the balance sheet. It is starting as income in the operating account, and you transfer the net that you get after taxes into reserves. And that's just my legal opinion, which may differ from that of your CPA.
And just a reminder to everyone, we can give general advice, but for something specific like this and how interest should be calculated, please talk to your CPA. So next question. Can you provide a refresher on smoking inside condo units and the board's ability to pass a smoke-free rule? So under the new Act 6434 304 sub 1 sub F, this also is similar language in Ukiah and the HOA Act as well. The board has the authority to regulate the use, maintenance, repair, replacement, and modification of the common elements, which includes the limited common elements. So the board can, by rule, prohibit smoking in the common and limited common elements. However, restrictions on how owners use their property, meaning their units, must be in the declaration or a declaration amendment to be effective. And one very prominent example of this is all the litigation regarding rental caps. So the board cannot outright prohibit smoking in units by rule. There's no authority under the declaration or statute for the board to do that. However, if the smoking is such a problem that it is offensive to other owners, it might trigger a more general violation of the nuisance provisions in the declaration. In that particular instance, we strongly recommend you contact your association attorney to guide you through this process. So just in a nutshell, the board can regulate by rule smoking in common and limited common elements, cannot in the units generally. If the smoking is a problem for a specific unit, there may be enforcement avenues available, but contact your association attorney. Ken, did you have anything to add to that?
Yeah, I would say sort of generally that rules regarding activities going on inside the unit have to be related to something that is affecting the neighbors. So when we have rules about smoking or dogs or noise, those relate to how they are perceived and impact the neighbors, not what's going on inside the unit. And it has to be severe enough that it would justify a prohibition on the activity by the board. And it becomes very fact specific. So next question is, on the subject of association meetings called by petition, can members overrule a decision made by the board that would normally fall exclusively under the board's authority, such as schedule and locale of board meetings and architectural approval, choice of association vendors, et cetera? Or is this limited to topics that the membership would normally have a vote on, such as removal of directors, passing a budget, changing a rule, et cetera? Is there any topic that cannot be considered by association meetings called by petition? So again, I'd need to know specifics to be able to give an actual answer to a client. But generally, we believe that owners do not have the authority to overrule board decisions when that authority has been granted by statute or the declaration. Owners get to vote to elect or remove board members, and they can certainly affect a board decision in that manner. And owners have to vote to adopt declaration of bylaws amendments, and they can vote to reject expenditures by rejecting budgets and special assessments. But that said, there are some governing documents that provide the specific authority to the membership to adopt or to veto rules that would be different from those adopted by the board. And some will even state very explicitly that if the membership has modified a rule exercising its authority in the document, that the board is not allowed to turn around and change it again. So if enough owners have an issue with how a board is adopting rules, they can certainly recall the board members and they can elect new. But you would create an unworkable situation if you started to require that you have a meeting of the association every time you wanted to adopt a rule or make a change to the late fees for the association's payments, or make changes to fine or enforcement policies. So the board of directors is an elected group, and it is given substantial authority by the legislature. And so the general rule would be no, the owners cannot just call a meeting to make a different decision. So did you want to say anything else on that, Jennifer?
I don't think so.
Well, I guess I will. The one other thing I would add is that certainly the board can influence, or excuse me, the owners can influence the board by letting them know how they feel about something. So you could call it an advisory vote, but it doesn't mean it's binding on the board. Sorry.
No worries. And if anyone wanted those statutory references again, I just put them in the chat. So moving on to the next question. Does the strictness of adherence to Robert's Rules of Order impact the soundness of decisions made by the board or the members? For instance, Robert's Rules discusses the ability for members of a body to reconsider a topic, add orders of the day, or to dispense with the rules, and sometimes have voting percentages towards 2/3 to accomplish these actions, as well as specific instances of time where these actions can be taken. Is it harmful to the decisions made in terms of its ability to be upheld in court if the votes are taken as a majority when Robert's Rules requires a 2/3 vote to succeed, or when taken up at a time when they do not have priority or cannot be taken up? So Robert's Rules is a guideline for how boards conduct business. It is not binding. It is not statutory or a requirement. So Robert's Rules do not override voting percentages set in statute or by the governing documents. So just in brass tacks, most boards, even when Robert's Rules are recommended for procedure, don't follow them precisely. And there's no reason to. As long as the board's actions are reasonable and the majority of the board agrees with a particular action taken at a meeting, then no court is really going to override that decision. Trying to use Robert's Rules to invalidate process or invalidate a vote based on process would fail in a court if it complied with any process set by statute or the governing documents, especially because the members, the owners, have the means to call special meetings and recall board members. So the statutes that I just put in the chat regarding how the that the board acts for the association. The action of the board is the approval of a majority of quorum present at a meeting, or outside of meeting, unanimous consent. Anything else really doesn't matter. So if you're using Robert's Rules, you can use it as a guideline for how you conduct business, but it does not bind the association or owners or the board into how particular votes are taken, or because it's majority of quorum. And I think I'm confusing myself. Ken, did you have anything to add to that?
Well, the way that we write our bylaws when we are, doing it for associations is that you would never look at Robert's rules unless there is a dispute about the process you are using to make a decision. There's no reason to do it. Most boards can function, and most meetings for associations can be conducted with the membership understanding the questions presented and addressing them. So you would only go to Robert's rules if there's some dispute about how to deal with it. So the next question is, once an audit is done on the financials of the association by an outside company, who should sign off on the audit? The president and the treasurer, question mark. So our thought is that it doesn't really matter. The board should be voting on whether to accept the audit. I don't think it's that the board actually can approve or not approve the audit, because it is the CPA's opinion. And so usually it's the board, quote, accepting the audit. And it's really a meaningless gesture, because the CPA's audit is the CPA's audit is what it is. The board cannot affect it after it's been presented. And mostly you're just confirming that the board has received the information. So we would think the president and treasurer would be fine. I'd think if the secretary signed it, because the secretary has specific duties related to records, that would also be okay. But it should be that when the audit is completed, it is presented by the board. There should be a acknowledgement in the board meeting minutes that the CPA audit has been received. And if the board makes a motion to accept it, that would be reflected in the minutes. Anything you want to add, Jennifer?
We have a follow-up question. Can the manager sign the audit and taxes?
Well, the signature on the audit, at least in my opinion, is a representation that the client has received it. And so if you had a board meeting minutes that reflected that the board had received the audit and reviewed it, I don't know that it would matter. But if the audit comes in and the board never sees it, I don't think the manager should be signing it. In terms of the taxes, I think that in many of the management contracts gives the manager the authority to sign on behalf of the association. And I'd want to know the specifics of the management contract. I might want to, again, be assured that the board of directors saw the tax return and approved the tax return for filing. And at that point, I don't know that it would matter whether the president, treasurer, secretary, or manager signed it on behalf of the association.
Okay, moving on to the next question. Does the 2021 change in voting laws mean that we can amend the covenants by absentee ballot if the declaration says the covenants may be amended, and quoting, by a majority of members who are voting either in person or by proxy at a meeting called for that purpose? Do absentee ballots count towards proxy? So the statutory references here are 6432-280, 6434-340, 6438-120, and 6490-455. So the answer to this particular question is maybe. The question as it was submitted is a little too specific, and it's determined not just by the language you cite, but also the subject matter of the change. I know I spoke a little earlier about the litigation regarding rental caps, and this particular area is one where the specific language in the declaration and the specific language in your governing documents may change the answer. So if you have a specific situation that you're looking at, please contact your association attorney who can advise you on your specific facts, circumstances, and governing documents. So absentee ballots are a way the legislature gave associations the ability to conduct votes at meetings where owners can't or could not be present. So when a meeting is held, the board sends out absentee ballots along with a notice of meeting, and it allows owners to vote how they wish to without having an actual proxy. So absentee ballots will count towards quorum, and then we're not sure exactly what is meant by proxy here because there's no proxy requirement, it's quorum. They are a substitute for a proxy and must be prepared by the association in advance of the meeting. Owners can prepare their own proxy forms, but not their own absentee ballots. So as an association, if you have a vote that you want to conduct, you can hold a meeting and send out absentee ballots along with the notice of meeting. You can send out proxy forms or have owners submit proxy forms. What proxy forms do is allow the person listed on the proxy to vote for that particular unit or lot, whichever you have. So an absentee ballot allows that owner to tell the board, I vote this way. And it's like they were attending the meeting. A proxy is when that particular owner says, I can't attend the meeting, I'm allowing this person to vote for me. So that's the two major differences. Proxies may or may not count. Actually, proxies would count towards quorum. Absentee ballots always count towards quorum. Ken, did you have anything to add to that?
I'll just add that one of the specifics in the question was stating that they could amend their covenants with a majority of the people in attendance at a meeting. And under Ukiah, as it comes into effect, we think that that provision would likely be invalid and you'd be required to follow 67% of all owners as stated in the statute. And so that's another reason why we're hesitant to answer a question like this without seeing the specific governing documents. And we've certainly been in arguments with owners' attorneys about whether or not the majority in it vote is of those in attendance or of the total membership when a vote didn't go the way a particular owner wanted. And so that's the process. If you were amending your covenants, should certainly be reviewed by an attorney. It's, going to affect a document you're going to record, and you want to make sure that it's done properly. I guess I'll also throw in that we have seen many improperly recorded amendments because there's a specific process and provision in the statute about information required for an amendment, which includes a reference to every prior amendment. And we frequently see improperly done amendments by board secretaries or managers where they have failed to include all of the prior amendments in their recitals. So make sure you follow the process if you're doing an amendment. Next question. In Washington State, are there governing rules for dogs by size or weight, not including service or emotional support animals or other working dogs? So the short answer is no. There are no limits on the size of dogs which people can have. There are some limits in many municipalities, meaning cities and governments, on the number of dogs which can be kept in a residence, but we're not aware of any statewide laws regarding size of dogs. And then we would also normally recommend it to clients that even though it may be easier to write a rule about the size of a dog or the weight of a dog, that we would usually look for enforcement based on the behavior of the dog rather than the weight or the size. And we would really need specifics about what you're trying to accomplish to provide more advice. Anything to add, Jennifer?
No. Next question. Are homeowners responsible for trimming and maintenance of trees and shrubs next to their units within the 5-foot unlimited common area space? And we can't answer this question. The reason being is that the answer depends on what's in your governing documents. The answer could be in the declaration, it could be in the survey maps and plans or plat map. This is too specific for us to answer if you, and we suggest you submit this question to your association attorney. Ken, did you have anything to add to that?
No. Next question. If an HOA board member and officer is delinquent in paying their special assessment and unresponsive to email, text, or phone communication, what would be the proper notification process for the board to follow? And that would preserve the board's ability to effectively place a lien on the property and eventually foreclose if necessary. In other words, does the fact that the person is incommunicado, I'll try again. Does the fact that it's an incommunicado recalcitrant board member who is delinquent rather than a non-board member change the standard notification process? Well, the short answer is no. There's no difference in your collections process for a board member than for other owners. And if your board member is not communicating but shows up for a board meeting, I think it's certainly an opportunity you could ask them about the delinquency. But the method of notice is provided for in the statute and your governing documents. And so that is exactly the process you should use regardless of the status. I will note that under Ukiah, the board is allowed to remove a delinquent board member from the board. So you don't have a board member who is both delinquent and refusing to show up for meetings and refusing to communicate, which means you have a non-functioning board member. So there is a process in Ukiah that if a board member is delinquent, I think it's more than 60 days, that you can give the board member notice and they have 30 days to cure the delinquency. And if they do not cure it, I believe it takes a 2/3 vote of the remaining, or a 2/3 vote of the board to remove the board member from their position, and you can fill the position as any other vacancy. Anything you want to add, Jennifer?
No. So next question. A board presents an amendment to owners for signature, which changes a liability on owners. If it passes and the board does not notify owners that the amendment is recorded, are owners liable for the increased liability? So the way this question was worded is a little odd, but generally, yes. Once an amendment is recorded, it's effective. So we certainly advise our clients that when an amendment to the governing documents pass, they inform the owners of that fact and inform the owners of the results of the vote. The precise facts of your particular situation may change our answer. It also depends on how much time has passed since the document was voted on or recorded. That could make a difference. But notice of the text of the amendment was included with the vote. The amendments passing should be contained in board meeting minutes. So generally, a lot of our clients will pass an amendment. The passage should be noted in board meeting minutes. The amendment is sent to us for recording. It's recorded. And then the management company or the board puts a notice on the association's portal or website. That's sufficient notice to the owners that the amendment passed and is effective. There's no need to send actual notice to the owners that the amendment passed or that the amendment was recorded. You certainly don't need to send out another copy of the recorded amendment. It's public record. Ken, did you have anything to add to that?
Yeah, just this is another one where the specific facts are going to start to make a big difference on how we might advise a client. And depending on what kind of liability you're talking about, we may or may not tell you that it would be prudent to not to enforce it in a particular circumstance. But the courts have this sort of imagined notice as having been effective when a document is recorded with the county because it's a public record. So theoretically, just the fact that it's recorded and you have a chance to know from the county that it's been recorded is good enough record for most amendments. But there's probably something hidden in this question we don't know the answer to. All right, next question. What is required for a board that is subject to 6438 and the Homeowner Association Act and the Miscellaneous Nonprofit Corporation Act to appoint an advisory committee? Currently, our governing documents say nothing about advisory committees. So the short answer is the board can appoint an advisory committee anytime it wants and make up its membership in any way it wants, because it is not exercising any of the board's authority. So if you want an advisory committee to look at landscape or propose some kind of a modification to your parking lot, you can certainly do that. And I would suggest that it's a way to get involvement amongst your community and to get more information than what board members may be able to get independently. So, best practice would be to have a charter for the committee, which specifies the makeup of the committee and what it is tasked to do by the board. And it would also generally state that the board can appoint and remove the members of the committee at any time, can dissolve the committee when the committee's work is done, or the board is, satisfied that it doesn't need the committee any longer. I certainly have at least one client where there's a advisory committee of 3 and it's completely separate from the board, and the advisory committee is not happy with board decisions. And it's a small community, so you've basically got 2 factions represented, but the advisory committee has 0 legal authority and capacity. So the membership would need to remove the board if they want to follow the advice of the advisory committee. So anything to add, Jennifer?
No. And just a note for people, we probably will have time for questions at the end. So if you have any questions that you'd like us to answer, please put them in the chat and we will try to get to them. So next question. When comparing Ukiah with the Condo Act, Ukiah allows for the withdrawal of funds from reserves for reserve repairs when these items are not listed in the reserve study and does not require notification of repayment or repayment requirements to owners. Prior to Ukiah coming into effect, can an association adopt an amendment that makes this requirement prior to January 1st of 2028 so that it overrides this section? Is there a threshold amount that requires a vote of the owners under both 6434 and 6490? And I'm not sure exactly what question you're trying to have us answer, but under 6434 384, that particular statute allows the association to pay for maintenance, repair, or replacement of reserve components out of cycle without notification requirements. So this means if you have a reserve component that fails early, you can pay for those repairs or replacement out of reserve funds without following the notification requirements in that statute. However, any payments or anything, let me back up, I'm sorry. If you pay for any sort of operating expense out of the reserve fund that is not maintenance, repair, replacement of reserve components, you are required to inform the owners and pay the money back within 2 years unless it's an undue hardship. So if the question is asking if the association could amend the declaration to allow for payment of non-reserve components without notification, the answer is no. The declaration cannot override statute. So if you have components that are in the reserve, that are, that should be in the reserve study but are not, just change the reserve study to add them. And let your reserve specialist know that these should be added and put on the reserve study. What we think the legislative intent for these provisions in 6434 and 6490 is that associations should be able to pay for repairs to the building or to the common areas out of reserve funds. The notification requirements and requirement to pay back the reserve is for general operating expenses, not maintenance, repair, replacements. So if the question is, can the association have a limit on what it spends for maintenance? The answer is really no. The language in most declarations regarding limits on what can be spent are for capital improvements. Capital improvements are something that the association is putting in that was not there present before. As an example, putting in a pool when you didn't have one. If you have a pool or some other component that needs maintenance, repair, replacement, that's not a capital improvement, that's maintenance. So for a capital improvement, reserve funds should never be used to install a capital improvement, but once a capital improvement is made, that capital improvement should be added to the reserve study and then follow the normal procedures for maintenance, repair, replacement of that new component. So typically, there is no requirement for ownership approval to repairs of existing components. It's only when there's a capital improvement. Ken, did you have anything to add to that?
Well, I just would offer, I think that the two statutes have the same legislative intent. So even though there is slightly different wording about the ability to spend money, I think the intent was the same, that a board is not prohibited from spending money on a building component just because it's missing from the reserve study or is not scheduled for repair at the time you need to fix it. But anyway, next question, which is a good question and one we do not have as an industry an answer for yet. I have a question about the best practice for secret ballots as required by 6490-455 subsection 9. This is a new section which came into effect in June of this year. It seems to require secret ballots for board elections, removal of directors, and any amendment to your governing documents. And I'll stop and say, yes, that's true, it does. What is the best practice for secret ballots? And more specifically, what's the best practice for secret ballots with regards to recalling a director? It seems the director should have an opportunity to address the association before owners vote. So there would be a meeting notice with the secret ballot, but a return date for the ballots after the meeting. So this is a question with no good answer because we don't have a process that goes along with the requirements. As regards to removing a board member, it's true that you are required to give the director an opportunity to speak to the membership before a vote is taken. So I think it would be necessary to actually call a meeting, which gives that opportunity to the director. Normally, you would be voting at the meeting, but the statutes also do allow for voting by mail. So I suppose it would be possible to both call a meeting and then have a vote by mail following. I think if you called a meeting and collected ballots in advance of the meeting, you would not meet the legislative intent of giving a notice or an opportunity for the owner to speak before the vote is taken. So there are a couple other competing sections of the new statute which make the secret ballot process more difficult. One is the statutory requirement in the same section, which is 649455, subsection 4, that the association implement reasonable measures to verify that each ballot in a tangible medium and electronic ballot is cast by the unit owner having a right to do so. So what that means is you can't just mail out ballots and have them all come in without the owners indicating who they are, because if you did that, you wouldn't be able to verify that the votes were cast by the person who is sent out the or who has the right to vote. Okay. So it is a puzzle which we have not had to deal with. I mean, this statute has only been in effect for 3 months. And so I'll be interested to see how different associations and management companies try and resolve it. There are certainly ways to control the method by which you give ballots to people. So if you mailed ballots only to persons who are authorized to vote, maybe that's a way of complying with the requirement to verify that it's been cast by the unit owner. If you were to, at a in-person meeting, be handing out ballots, that is almost certainly a way to verify, because you would just give ballots to the people who are entitled to vote. If you were to do this electronically, then sending the electronic notice for voting to an email registered with the owner that you can verify is likely to qualify as a reasonable means. And so we know that some of the electronic voting systems are being used that way, but you could certainly not use something like SurveyMonkey to do it, because there'd be no way to regulate who got onto the platform, or even regulate how many votes each person cast. So one of the things I might do is say, well, look at the procedures used by the government. So right now we have ballots going out only to registered voters. So if you give ballots only to the owners who are entitled to vote, that's a good step. We also have a process in our government ballots where the voter is supposed to sign the envelope that they return the ballot in as proof of their entitlement to vote. So you could have some process where the ballot comes back and the vote is separate from the envelope, so that you could confirm the identity of the person voting and then still count the ballot separately. You know, the reality is somebody has to count the votes. So somebody is going to be able to know how every person voted, whether it is the electronic system, which is tallying the votes, or whether it's the person who's collecting the paper ballots, if they indicate the name and unit number for every person who's voted. And so you're probably going to set up either a committee that is going to do the vote counting, or the management company is going to do the vote counting. And the secret ballot component of this is going to be preserved, because only that select small group, or only that manager, is going to actually be able to know how each person voted, and they will just give the results of the vote to the full membership. So it's a good question. It's one we don't have a great answer for, especially because the procedures by which your community might want to vote are going to vary so significantly, with a decision to have an in-person meeting or not, a decision to try and use absentee ballots or not, a decision to use electronic voting, even if you hold a meeting first. So I guess I'd recommend that if you have a vote which you are concerned about, or you think is going to be contested, that you work with your attorney to get a process which is unlikely to be challenged. And we have done this in the past with clients where often it's after the first vote, we will be working with an attorney for an owner or group of owners to establish a process which everybody agrees is going to accurately collect and tally votes. We've even had some elections where all of the ballots were sent into both law firms at the same time, and the law firms independently calculated the voting results and shared their results with each other to come to a conclusion as to who the successful candidates were. So if you know you've got a vote that's going to be contested, you might want to start out with a process that is not going to be challenged. You want to add anything on that, Jennifer?
I don't think so. So the next question, and this is the last question that we have prepared, so we may have time for a couple in the chat. Does new Washington state legislation allow owners to place air conditioner units on common areas without board approval? And these particular statutes that I'm putting in the chat are what this question is referring to. So the legislature this year added a new statute to all of the governing statutes regarding heat pumps or air conditioners. The answer to this particular question is no. So the board, under these statutes, boards cannot outright prohibit owners from installing air conditioners or heat pumps within their units. Now, we think this particular language wasn't necessarily understood by the legislature, but the legislative intent is that heat pumps and air conditioners must be allowed, but the boards are able to have reasonable regulations, such as placement or requiring the proper permits be pulled, requiring a hold harmless agreement to make that owner and any future owners responsible for that installation, etc. So the reasonable regulations cannot be an end run around the statute to make it impossible for anyone to install them. But the board has the authority to approve the installation and where the installation is. So we would encourage boards to find a way to allow the heat pumps, but we also expect that the statute is going to be changed to fix that particular wording that states that they must be allowed within the unit, because the exterior and air handler piece is generally outside of the unit boundary. The legislative intent here is very clear that heat pumps must be allowed. Ken, did you have anything to add to that?
No, it's, they're not, the owner does not have an entitlement to put anything inside the common or limited common elements. That's the statute's written that way. But I agree with Jennifer. I think that the legislature did not understand that they were not opening the doors to heat pumps for everyone, which is what their intent was. But I think that's the end of our advanced questions. If there's another question in the chat, someone could read it to us.
There are none yet.
Well, then we could all go and carry on with our day. Thank you, everyone.
Have a good day.